Welcome. My name is Brett Osmond, and I'm the editor of Compass. Lovely to have you here today for what should be a really interesting conversation on enduring powers of attorney. First of all, I would like to say that Compass is a project of Elder Abuse Action Australia, who work very closely with organisations right across Australia to raise awareness of elder abuse and to put forward strategies to reduce, prevent, and help people respond to abuse in all its forms. I'm coming to you today from Sydney on Gadigal land, and I'd like to pay my respects to elders past and present. And I'm really delighted that we've got today Sadie Davis, principal lawyer from Justice Connect in New South Wales, who is joining us to take your questions on this really interesting and sometimes complex topic of enduring powers of attorney. So just a few tips for today. We will be using the chat. So please jump into the chat and put your questions to us, and we'll endeavour to come back to you. We will be recording today's session, so we will be sending out a recording tomorrow, along with links to some really important documents. The title of this series is You Decide Who Decides. And You Decide Who Decides is a guide to helping people make an enduring power of attorney. It was first published back in 2019, and a new edition was just released yesterday. So we're really excited to say it's available on Compass. You will be sent a link to that tomorrow, and it is produced by the Australian Guardianship and Administration Council. It also comes with two really helpful introductory videos. We also on Compass have a lot of information on enduring powers of attorney, so I'll put that in the newsletter tomorrow, and we'll be referencing some of those articles today. But Sadie, welcome. Lovely to have you with us.
Thank you, Brett. Thanks very much for having me. It's a pleasure.
Now, I thought we probably should start out by, answering the basic question: what is an enduring power of attorney for financial decisions?
So in New South Wales, we call it an enduring power of attorney. And it's a document where a person can appoint one or more people to make decisions, financial decisions on their behalf. So that includes both financial decisions and legal decisions. And you can choose for it to be effective immediately or to be effective at a later point in time, which I'm sure we'll go into during the session.
And how does it differ from a standard general power of attorney?
So, a general power of attorney is a document that you put in place for a specific time, and it is only effective if you have capacity. So, for example, you might put in place a general power of attorney if you're going on an overseas trip, or if you are incapacitated for a short period of time. An enduring power of attorney continues to be effective when you lose, or if you lose the capacity to make financial decisions.
So why should people consider having an enduring power of attorney?
Well, it's a good question, and obviously I do advise my clients to put these in place because you just don't know what your future has in store. So, for example, you may have some sort of accident or develop dementia, whereby at some point in the future, you're not going to be able to make decisions on your own. And it's an opportunity, while you do have capacity, to choose the right person or people to make those decisions for you, because it is a really powerful legal document.
Yeah, yeah. It's one of that. There's actually, and I'll put it in the newsletter when we send it out tomorrow. There's a terrific video produced by the Public Guardian in Queensland about capacity and the chances of people losing capacity. And we do know now that dementia is something that affects a lot of people, particularly over the age of 65. And so it's one of those documents, isn't it, that you have to make before you lose capacity. You can't make it after you lose capacity. Is that correct?
That's absolutely right. And it is really important to consider it early and because if you lose capacity and you don't have one in place, then you lose control of choosing someone to make those decisions for you when you lose capacity. So yes, it's really important to put it in place while you do have capacity.
Now, we will come back to that issue of, what if you don't have an enduring power of attorney? But before we get there, why don't we talk about probably what is the most important thing with respect to an enduring power of attorney, and that's choosing the right person. And so, what recommendations do you have for people when they're thinking about who to choose?
Yes, so I think you need to choose someone who's got the requisite attributes to be a good attorney. So, an honest person, someone who you know is able to manage your legal and financial affairs, someone who doesn't have any issues that might impact on their ability to do that in an honest way, such as personal issues like gambling issues or drug and alcohol addiction issues, which might get in the way of being able to do a good job. Doesn't have to be your adult children. It can be another person in your life who you know can be objective and to also be someone who will follow your wishes.
Yeah. You really probably, if you can, choose somebody who knows you well, knows, it might even sound glib to say this, but knows the kind of things you like to do, how you like to dress, the way you like to live your life, the values you express in the decisions that you make. Those sorts of things are kind of, everyday matters would help if a person had good knowledge of you, wouldn't it?
I think so. And I think what is really important with these financial powers of attorney is that someone, your point, knows where your assets are, knows how they find any information they need so that if they were to step into the role, they can do it well. So having someone who you can trust and who you probably have had in your life for a significant amount of time and
Mm.
who has gone through the test of time in terms of you've seen how they've dealt with situations in an honest and accountable way.
Yeah. Now, I just wanted to mention to everybody, please put your questions forward in the chat and we'll jump onto them. But just on that question of the attorney, there are two great articles on Compass. One is called How to Choose an Attorney, and the other one is How to Be a Good Attorney. So I do recommend both of those to you. Now, there are other guides available from other, terrific organizations which are featured on Compass as well, from legal aid around the country. So they are also available because it doesn't come when you're appointed an attorney with a mandatory manual on what to do. You sort of almost have to learn on the job, don't you?
You really do. And when you sign a power of attorney in New South Wales, there is a requirement for a appropriately qualified person to witness your signature to show that you understand what it is you're doing. However, there's no equivalent to make sure that your attorney understands what it is that they need to do. And so when they do sign the document, it does say that they have to act honestly, that they have to keep their own money separate to yours, that they have to follow your wishes when appropriate. But as you say, there isn't a manual, so you just need to appoint someone who will do the job.
Now, just to sort of finish up on that attorney question, I know, I'm approaching 60. It was only a few years ago I got my own enduring powers of attorney in place. And like many other people, chose my partner and then my two best friends who are my age. And so I've actually got my niece as a third backup, who is only 23, a very responsible 23-year-old. And so that can also help, can't it? Because you do want to potentially factor in. I know a lot of people choose their adult children, but you could choose a niece or a nephew or somebody else in your life that is younger.
Yes, absolutely. And I'm glad, Brett,
Backup.
that you have got the documents put in place. Well done. So it is important to have a backup. And I
Yep.
think as we do get older, our friends and family and partners get older as well. And so, like us, we don't know what's going to happen to them in the future. So, to have a younger person as a substitute can be a really good idea. And I think your point also about it not having to be your adult children, for it to be another friend or relative that has those qualities that you think are important, then that's a great option. Not saying that your adult children aren't an appropriate choice, because they often can be,
Hmm.
but not always. And it's important that you don't be pressured
Yeah.
into appointing someone because they suggest it to you, because they put pressure on you to appoint them.
Yeah.
So yeah, that is really important.
Great. Now we're getting a few questions here. Just before I go to them, you can also appoint a lawyer, couldn't you? You could appoint somebody in a professional capacity, but that would cost. I mean, there'd be fees associated with that. It doesn't have to be somebody that within your family or friendship group, because we often get asked at Compass, well, I don't have anybody that I think would be suitable. And one of the things that I know that I've read is if you can't identify someone that you can trust, then it's probably best not to have an enduring power of attorney. What are your thoughts on that?
I totally agree with that. If there's no one in your life that you think is appropriate, then don't appoint an attorney. If you do have a professional person who you trust, then certainly that is an option. As you say, Brett, you will need to pay for that. The other option is the New South Wales trustee and guardian. So you can appoint the public trustee as your attorney. And again, they will charge for that service, but that is another option.
Another option. Now we've got a question here from Adelina. She says that my enduring power of attorney is jointly to my husband and son. My husband passed away, condolences, Adelina, in 2019. Is Adelina's enduring power of attorney still valid? Or does she need to execute a new one?
Okay, so thanks, Adelina, for that question. So, what you need to do is have a look back at the document, because in that document, it will actually specify whether the appointment continues to be valid, the joint appointment, if one of those attorneys passes away. So, go back to your document, have a look, and it should specify that there. So, that's important to do that, because sometimes the document can finish once those joint attorneys or one of those joint attorneys passes away.
Yeah. So potentially have a look at that, Adelina, and potentially seek some legal advice there. We've got a question from Christina. Um, how do you find the experience of enduring powers of attorney living overseas? Christina's EPOAs or attorneys are living internationally. I know that one of the recommendations in You Decide Who Decides is that the person or people you choose, ideally should live close to you and would be able to do things in person. So I guess it really depends on the types of things that might be required of your attorney, and some of those might actually be time sensitive. and require involvement in your day-to-day life. So what are your thoughts on if your attorneys are living somewhere else in the world?
Yeah, it's an interesting question. I think that it is important, if you can, have someone local. However, if there is someone who you trust who lives overseas, it is doable. But what you need to check is that person able to come back here if needed to do particular things? In these days of online access to banking, it is more doable for an attorney to be able to pay bills, etc., while they're overseas. But there will probably be a need for them to come back to Australia at some point to do the requisite paperwork.
Now, we might just mention here that in New South Wales, an enduring power of attorney is only for financial matters. And today's session is about New South Wales, but it's not true of the document in other parts of the country. In fact, actually, about 4 states and territories, it's only financial matters, and I think it's about 3 or 4 states where it actually includes health and lifestyle matters. So I also think probably, Christina, your enduring guardian, even though we're not talking about it today, which would be responsible for your health and lifestyle, is something that you probably would very much want living in the same area as you. But we've got information on both topics on Compass. A good question here from Lois. Does your attorney have to reside in the same state?
No, they don't. Again, it may be important at some point for that attorney to come to New South Wales to fill out some paperwork. But no, they don't have to live in the same state as you. And in fact, different states have an agreement whereby you can register your interstate power of attorney in different jurisdictions. But if you appoint someone interstate, that's okay. But the preference is to appoint someone in New South Wales.
Great. Now, in New South Wales, can you register your enduring power of attorney, or do you, in fact, have to register your enduring power of attorney?
So you can register your power of attorney in New South Wales, but you don't have to. So if you want to register it, you can register it with the Land Titles Office, and you do have to register it if you're going to sell property, buy or sell property. So that's the circumstance in which you have to register your document.
Right. And I would think in a practical sense, assuming, let's say, I get old, I lose capacity, at some stage, there may be an instruction to sell property in which to finance my care. Should I need to move into different accommodation and so that is something very important for people to consider. Now, when you've created your enduring power of attorney, what should you do with it? I mean, if you don't register it necessarily, I'm assuming you need to give copies to people. And probably the more copies you give to the close people in your life, the better. Do you agree? Or what's the sort of standard or benchmark that people should be thinking about?
Okay, so the important thing is for an original power of attorney to be stored somewhere safe.
Yep.
So whether that is with your lawyer, with New South Wales trustee and guardian, or in a safe at home that's fireproof and lockable. So that's the important thing. Let your attorney know where the original document is. You can provide copies to other people in your life, but just remember it is a really powerful document. And so I wouldn't be spreading it far and wide. I'd be keeping it fairly close and just giving a copy to your attorneys. They would only be able to act on it if it's certified. So a certified copy of the original document. So that would be my recommendation.
Right. Good advice. Thank you, Sadie. We've got a question here from Kate. I hope I pronounced your name correctly. I've had an enduring guardian for many years. Is she able to be my attorney as well, or should it be a separate person? My guardian is not related to me and is 20 years younger than I do. I have then I and I have adult children. So I think the question really is, can your enduring guardian also be your attorney under an enduring power?
Yeah, they certainly can. You can have the same person. Just keep in mind, though, as I said earlier, is there someone else in your life who may have uh, better qualities to be able to manage your finances? So sometimes a person who you trust to make good decisions about your health and lifestyle might not be the same person that you trust to make decisions about your finances. They might have not have the right skills to do that, but
Yeah.
certainly you can, yes,
Yeah.
have the same
Okay.
person.
We've got a good question here from Lincoln. Lincoln asks, what happens if you don't have an enduring power of attorney? It's a really good question,
Yes.
because a lot of people don't. And then what happens if you don't have one and you do actually lose capacity to make your own decisions?
Yeah, that is a great question. Thank you. So, what happens then is that if a decision needs to be made, then someone who has an interest in you can make an application to the New South Wales Consumer Administrative Tribunal, to NCAT, to be appointed as your attorney. It may be that if you're in hospital, um, that the hospital itself makes that application, and then NCAT will make the decision about who to appoint, whether they appoint a family member, a friend, the public trustee to be your financial manager.
Yeah, and I guess you mentioned control earlier. I guess the enduring power gives you the control to put the instructions down on the decisions you want made on your behalf. And I guess to some extent, if that goes to the public trustee, you do lose a little bit of that, don't you?
You absolutely do. And also with the public trustee, you don't have a person who knows what you want and what your interests are, what your personality is like. And the NCAT may also decide to appoint a family member or a friend who you wouldn't have chosen. So that's another reason why it's a really good idea to put an enduring power of attorney in place.
Yeah, yeah, yeah. This is an interesting question here from Kathy. Kathy says, my partner recently activated his EPOA via a GP certificate, giving me the EPOA. So Kathy is the attorney for her partner. A few years ago, I appointed him as my EPOA. What should I be doing now?
Oh,
So it's probably a situation
interesting.
where
Yes.
Um, if your partner, Kathy, has lost capacity and you still have it, that you might be wanting to consider
Yes, yeah,
making a
that's a
change.
really important
Mm.
question. So it sounds as though your husband might not be able to act as your attorney. So while you have capacity, revoke that document would be the best option, and putting a new one in place, appointing someone who does have capacity and the ability to make decisions. You may already have in your existing document a substitute decision maker. Uh,
Mm.
so, yeah, that would be another option, that if your husband is not able to do it, but you've got a substitute in there, then they could step in.
Yeah, and you don't have to do anything. It's already
Exactly.
there. But these
Yes.
documents can actually last a very long time. So you do have to look well into the future. And often people create them and then sort of set them aside and don't look at them. It's probably advisable to look at them every few years. And
Yes. Yes.
would you suggest?
Yeah, I think that's a really good idea. Your life changes, and the people that you're close to change. So I would recommend that you have a look at them every 2 or 3 years, just to make sure that they're appropriate. I'm not saying that you should change them every 2 or 3 years, but just to have a look, think, is that what I want still?
Right.
Is a good thing to do.
Great. Now, we've got a question here from Elizabeth, which I think we've touched on, but I'll just read it out. We suggested that if you can't choose a person to be your EPOA, then it's best not to have one. I think the point we're making is if you can't choose someone that you trust, then it's probably best not to have one. What are the consequences of not having an EPOA? Well, I think we've kind of talked about that ultimately it would become something that the public trustee would be reviewing or looking at
Yes.
if
Yeah. So
someone has made an application.
yeah, that's right. So NCAT would have a look at it, and public trustee would certainly be one of the options that they
Right.
would look at.
Yeah.
It might be that a family member or friend puts their hand up and is willing to step into that role.
Great. We've got a question here, a good one from Kate. How do you revoke an enduring power of attorney?
Good question. So you need to do that in writing. It needs to be witnessed by an adult witness. There are forms, I believe, on the NCAT or New South Wales Trustee and Guardian website, perhaps. Probably best to do it with a lawyer to make sure you get it right. So you need to sign it. Your witness needs to sign it. And the important thing is that you need to let your attorney know that you've revoked it. So you have to send them a copy.
Yeah. Now, I should let you know that on Compass, under our Enduring Powers of Attorney section, there is a dedicated section for New South Wales. And within that, there is a checklist, and you'll be able to find the forms on how to make an enduring power of attorney, including the form to download to revoke it. And so they're all there in that one place. Now, Kate has followed up with a question, and thank you. I'm glad we pronounced your name correctly. Does she need a separate document to be created for your enduring guardian to be an enduring power of attorney? Well, they are two separate legal documents, aren't they? Yeah.
They certainly are, and you do need to have both, and they do cover quite different things. So the enduring power of attorney covers legal and financial decisions. Enduring guardianship appointment covers health and lifestyle decisions, and they are in New South Wales two separate documents.
Two separate documents. Adelina asks, can witnesses to your enduring power of attorney be related? Either or both to the attorney and the person executing the EPOA?
Okay, so in New South Wales, it has to be a particular authorised person who witnesses a principal or the person making the power of attorney who witnesses them signing it. So it needs to be a lawyer, or an employee of New South Wales Trustee and Guardian who witnesses that document. I would say that it would be preferable that it's not a relative who is that lawyer.
Yeah, okay. That's good advice. Nolene asks, apologies if this has been covered, but can you have more than one person as your EPOA? And it's a really good question because it opens up a few subsequent questions I'd like to ask you, Sadie.
Yeah.
So can you have more than one?
Yes, you certainly can. So you can definitely have more than one. You can have three. I wouldn't suggest that you would have any more than that. And you can appoint them in different ways. So you can either, say you have two attorneys, you can appoint them jointly. So they have to both make the decision together, or you can have them appointed jointly and severally, which means that they can either act together or they can act separate to each other. So they don't all need to agree. You can also appoint a substitute attorney. So that means that if something happens to your attorney, then the substitute attorney will step in. So there's a few different ways in which you can structure the document.
And We'll get to misuse and abuse a bit later, so I'll circle back onto that one. We've got a question here from Fiona Tate. Is it more risky to have power of attorney who are appointed to operate severally or independent of each other? Actually, this is the question I think I was going. If you've got attorneys that can act independently, is it safer to have that model or potentially safer to have them have to make decisions together? I guess
Yeah,
it really
thank you for
depends.
that
Yeah.
question, Fiona. It
Yeah.
is a tricky one. Look, sometimes in families or in other situations, people feel more comfortable if two people are making the decision.
Mm.
Whether or not it's safer, I'm not sure. But what I do suggest is that both of the people that you're appointing, you trust will do the right thing. And if you appoint them jointly, that they get on with each other and that you feel satisfied that they are going to make a joint decision. Because if it doesn't work out, then an application will need to be made to NCAT for the decision to be made, or possibly for that document to be revoked because it's not working.
Yeah. Now, just on the topic of risk, obviously it's a very powerful document, an enduring power of attorney. So it does come with some risks. I think that's one of the reasons why we keep circling back to this criterion of choosing someone that you can trust. I know on reading the You Decide Who Decides, there is a little case study here of somebody who has appointed their accountant to do an annual audit of their attorney. So obviously that would come with fees, but if people are looking for strategies to, I suppose, to put in layers of protection, that might be one they could consider.
Yes, they can. But look, I would suggest that if you've got any doubts about the person you're appointing,
Yeah.
don't appoint them. It's much better to not appoint that person, because it is a very powerful document. You can, buy and sell real estate. So there's a lot you can do with that document. Certainly, it might be a factor to put in place a way in which the attorney can be monitored by an accountant. But I would suggest to to not appoint someone who you think might be at risk in that way.
We've got a very good question here from Mary. Mary asks, can your power of attorney, enduring power of attorney, receive costs for dealing with your affairs? So that's a really interesting one. Yeah.
It is. It is. It depends on whether it's a professional person. So a
Hmm.
professional person can be paid, but a friend or family member can't. However, you can make allowance in the document for the attorney to be paid to pay themselves funds to override that conflict of interest situation. So, for example, if your attorney is financially dependent on you or lives with you, then there can be provision made for that. It does put the person in a powerful position. So you might want to limit that. And it may be a conflict of interest if they do need to pay themselves money out of your funds.
Yeah, yeah. Thank you. Sarah asks a very good question. If two people are jointly appointed, and I'm assuming that they have to make decisions, let's say they have to make decisions jointly, or even severally, how are disputes resolved?
Okay, so there's some services out there that might be able to help, like Relationships Australia,
Yeah.
to resolve the issues. If it really can't be resolved, then it will need to return to NCAT, and NCAT will make that decision.
Yeah, okay. It's a really good question. Thank you, Sarah. Therese has asked this question. If you have jointly held assets like a bank account, and the joint account holder is not your EPOA, and you lose capacity, who can operate the bank account?
Wow, that's a tricky one.
Yeah.
So, if it's a jointly held account, then either person can operate it. So, if your partner or whoever it is that you only have the account with loses capacity, then the remaining person can continue to operate it.
Yeah. Okay. I did want to move on. We've got a few more questions, but I'll come to them. What happens when a person is appointed an attorney? Even at the term an enduring power of attorney, it suggests that it comes with a great deal of power. But ultimately, the attorney is still required to support your decision making, aren't they? They're not a substitute decision maker in all cases. Their role is to be a supportive decision maker.
Absolutely.
Yeah, yeah, that's
Yes.
true.
So, up until the time that you lose capacity to make any financial decisions, the role of the attorney is very much to support you in making the decisions that you want to, because capacity is decision specific. So, you might be able to make a decision to pay a bill, for example, and so your attorney their role would be to help you to do that, but you may not be able to make the decision about selling particular assets or shares in
Mm.
order to do things. So you may need some more assistance with that. So there may come a point in time where you can't make particular decisions, and in that situation, the attorney would step into your shoes.
Mm. I guess, all of us as adults have the right to make mistakes. And I guess attorneys still have to respect the decisions that the principal wants to make and not necessarily impose their own values or on something that they might consider as extravagant or
Mm,
a
mm.
waste of money or not required. So yes, it's a fine line, isn't it, to balance?
Yes,
It's
yes,
a
but
challenge.
that's a really important point, Brett. It is your money,
Yep.
and you're able to do with it as you choose,
Yes.
even if other people in your life think that you're acting in a way that they may not themselves. So that is something that's also important when you're choosing an attorney.
Mhm.
Don't choose someone who has judgments about how you spend your money.
Yep.
Choose someone who is very much respectful of your wishes, and that will respect those wishes up until the time that you pass away.
Yeah, yeah, good advice. We've got a few more questions here. What happens from Amanda? A good question. What happens when a person dies for whom you hold an EPOA? And there are funeral costs that need to be made. My understanding is that the EPOA ceases once death has occurred.
Yeah, that's absolutely right. So it does, an enduring power of attorney only has effect up until the time of your death. And then that's when the will kicks in. So from the time of your death, the executor of your will be the person who pays funeral costs and does those other things that are required in terms of collecting your assets and distributing them in accordance with your will.
Right. We've got another question here from Adelina about conflicts of interest. Now, I should highlight there is an article on Compass about conflicts of interest. It's a big area and it should be talked about when you're choosing an attorney. Particular circumstance here that Adelina refers to is someone who has both a registered supporter under the new Age Act and an EPOA holder. How does one avoid overlap or conflict in decision-making authority? Um, might be outside the remit of our conversation today, but it does open up an interesting avenue of conversation.
I think so. And if you do have two different decision makers. Really important for that to be made clear in your document, who is making decisions over what. I think a power of attorney does make it pretty clear what those decisions are. So yeah, it's just important for everyone to be aware at the time that they sign the document exactly what their remit is.
Yeah, a terrific question here from Jules. One that I'm particularly interested in is capacity itself. I mean, who determines when you don't have capacity, and is it permanent?
Mm.
And Jules' question here, she's curious as to what are the situations, the legal documents that signal that capacity has been lost.
Yeah. So that's a great question. Thanks, Jules. So capacity is a very interesting area. So I think your question, Jules, was who makes the decision when you lose capacity? That's generally made by a medical practitioner. And some powers of attorney have the condition that they only become effective when I lose capacity and there's a medical certificate stating that I don't have capacity. So generally, that is the evidence that's required, is a statement or a certificate from a medical practitioner. However, it's not a permanent scenario. Capacity is fluid. It can change from time of day to what medication you're on, to whether you're under stress. So it is quite a fluid concept, and unfortunately, sometimes when there's a certificate there to say someone's lost capacity, it's difficult to then have that change. So important then to go back to the GP if things have changed and to get that modified.
Yeah, yeah. Because there's sort of four requirements of capacities, and that you understand the decision that's being put in front of you. You
Mm.
can weigh up options.
Yes,
You can, I can't remember, you can communicate an
communicate.
answer.
That's right. Doesn't
But
need to be verbally.
doesn't need to be verbal, right?
Yes,
Yes.
yes.
Um, so those are the factors, and yes, that can change. And people who have different cognitive conditions, even people with dementia,
Mm.
may have their cognition better at different times of the day,
Mm.
or
Mm.
throughout the week. So yeah, they have a really good question there. Um, and there is an article on Compass. I'm probably going to say this quite a few
Another
times,
one.
but there is another one called Having Capacity, and it's a really
Yes.
interesting area. And I do highly recommend it to you. So it's there at compass.info.
What a great resource it is, Compass.
Yeah, yeah. So we've got a question here from Sarah again. If a principal appoints joint enduring attorneys, are they called enduring attorneys, by the way? I think so, probably attorneys. I don't know the exact term, or agents or something else. Should the principal put an express direction or something similar that the attorneys must first seek assistance through Relationships Australia or a similar dispute resolution body? Well, I guess this comes to what kind of instructions do you want to give your attorneys
Yes.
for what scenarios, and yeah, what would be your approach to something like this that Sarah's put forward?
I think it'd be important to have that conversation with your joint attorneys about what process you want them to follow if there was to be disagreement. You could make that a condition in your power of attorney if you wished, for them to go through some sort of mediation process. I think joint appointments can be problematic where there is disagreement, and do consider whether joint and several might be a better option.
Yeah, yeah. Okay. I just wanted to say that yes, when we send the email out tomorrow, we'll include a transcript of all the questions that have been asked today. And so you'll be able to match that up along with the video. So that will be sent out to you. A question here from Lincoln. So I was distracted when discussing when disputes arise between two or more EPOAs. Please reply in one sentence. Yeah, I think I'll move on. I think we've talked about that one, so I will just put an answer in the notes for you, Lincoln. I did want to talk about essentially misuse and abuse of enduring powers of attorney. At Compass, we do hear stories from people, and I know one of the sentiments that is shared with us is that people fear putting an enduring power of attorney in place. And then at the same time, I know a lot of people don't want to have their lives decided by NCAT. But really, they're your only two options if you lose capacity, aren't they? Um,
Yes,
Primary options.
or appointing the New South Wales trustee and guardian.
Yeah.
Yes, but it can, as you say, powers of attorney can be misused, and it is a real problem. And I've seen it in my work. I work in a health justice partnership with older patients of St Vincent's, and I do see that they can be misused. An example of that might be that someone goes to hospital, they've appointed their child as an attorney, and the child goes and drains the bank account. So it can happen, and if something happens, then either you or someone with an interest in your life can make an application to NCAT to have it revoked. Even if the person who puts it in place doesn't have capacity, someone else can make that application.
Mhm.
You can make a complaint to the Ageing and Disability Commission. In New South Wales, we're lucky enough to have a body like that, where if there's issues of elder abuse, you can make that complaint. And there are criminal and civil penalties that do apply if you misuse a power of attorney.
Yeah, yeah. So I guess the advice is if you're aware of abuse um, in somebody that you know, that there are options available for you to report that and for action to be taken. Whilst that process might take some time, there are remedies available. So yes, we've got another question here from Adelina. Are there typical examples of elder abuse in relation to EPOAs? Well, I guess for financial matters, you do have the power to, yes, as you've just given in your example, remove money from a bank account, even sell real estate.
Mm.
So
Yes,
it's
I
quite
mean, there are a range of things that you can do with the document. You can get a loan from the bank.
right.
I've had situations in my work where attorneys have gone and done that without the knowledge of the person who appoints them. Have gone and got loans, have sold particular assets. So it is a real risk, but I wouldn't say that because the risk is there, don't appoint an attorney.
Yeah.
If there is someone in your life who you think would do a great job, do it. It's really important to have control over those decisions.
Yeah, yeah. So if someone, today listening to us talk wants to get an enduring power of attorney in place, where do they start? Do you recommend they speak to a lawyer, get independent legal and financial advice? And what options are available, if somebody wants to do it, on the cheap, so to speak?
Sure. So I would recommend to get a lawyer to do it.
Mhm.
If you can afford a private lawyer, you can get some recommendations from the New South Wales Law Society. They'll be able to point you to lawyers in your area or that might be able to assist you. If you're on a pension, you can get the documents done for free through the New South Wales Trustee and Guardian. So that's also an option, but you do need a lawyer to execute the document. And that is really important part of the documents. And hopefully it's a way in which lawyers can make an assessment whether or not the attorney is an appropriate person and guide their client accordingly.
Mm-hmm. Say you created an enduring power of attorney when you were living in Western Australia or Queensland or another part of Australia, but you've since moved to New South Wales and made New South Wales your home. Do you need to create a new enduring power of attorney, or can your original one remain in place?
Look, it can be registered with in the state you're living. However, if your assets are in New South Wales, I would recommend having a New South Wales power of attorney in place.
Right.
It will just make things more straightforward. If you were to, for example, need your attorney to sell real estate. And yeah, so they can be registered in the state you move to, but do consider putting in place one that is applicable to your assets.
Yeah.
Where
And
they
we would advise, going to Compass and having a look at the laws and rules in your jurisdiction, your state and territory. I think there are some particular rules and laws around if you remarry. And in the ACT, it makes some legal documents prior to that null and void, and you have to do them again. So it isn't the case in Australia that the laws are all the same when it comes to enduring powers of attorney. So it is wise just to read up on what is required in the place that you live. And all of that information is available on Compass. Mary asked a good question here. Can someone take out an enduring power of attorney if you are incapacitated?
No, they can't.
No.
So only you can take out a power of attorney. Only the principal or the person who
Yep.
is appointing an attorney is the one that can take one out.
Yep.
And if the person has lost capacity and you think you're the most appropriate person to act as the attorney, you need to make an application to NCAT. So
Yeah.
New South Wales Consumer and Administrative Tribunal.
Yeah. Yeah. Thank you. It's an interesting question. If say you reside in New South Wales or the ACT, but you own assets in different parts of Australia, does that have any bearing?
It may be that when you deal with those assets, that the particular body requires you to have a power of attorney from that state.
Mm-hmm.
It really depends on what you're dealing with. If it is a bank account, if it's real estate, and the requirements of the particular bank state. So yeah, it's a bit of a it depends answer.
Yeah. This question from Adelina, I'm not sure that we can answer. Adelina asks, what's a reasonable price to get an EPOA done from a lawyer? There are articles written about this, I think, from Legal Aid, New South Wales would be a good resource to have a look at. But you can do one yourself, obviously. But it's probably not something we could answer what a reasonable price or ballpark is. Do you agree, Sadie? It's probably something that
Yeah, I think you could go to the New South Wales Law Society if you wish. The other option is your local court. You might be able to get some assistance there. And also check with what the New South Wales trustee and guardian charge. But I can't really give an estimate.
No.
Sorry, Adelina.
Now we're going to wrap today's conversation up in a minute or two. So if anybody has any last questions, please put them into the chat. It's been a really interesting conversation. I know I've given a plug to Compass on a number of occasions, but it is a truly terrific resource with over 1,000 resources from lots of organisations, including NCAT, QCAT, and the various other institutions that we've spoken about today, Legal Aid and many others. It's a great hub, compass.info. You can sign up to our newsletter as well. We'll be sending out a recording of today's conversation tomorrow, along with links to some really important documents. Sadie, it's been terrific talking with you. I think we'll take one last question, which is from Therese. Are there any conditions or limitations you suggest should be included in EPOA, like for lapsing superannuation nominations, specific gifts under your will? Under your well, gifts is an interesting one, and I guess instructions. It really is up to each individual, isn't it? How detailed they want to make their enduring power.
Yeah, I think it really is. And I think to get some advice from professionals in your life, like an accountant, to see if there are conditions that are required for your particular assets is important. I do, though, often say to my clients that if they are appointing someone as their attorney, probably best not to limit what they do, because you don't know what situation they're going to be
Exactly.
in. So it's very hard to be able to limit, for example, selling a property. It might be that that needs to happen for you to be able to move somewhere.
Yeah.
And it just makes it tricky if you do put conditions in place.
Sadie, thank you so much. Your experience and knowledge has been invaluable. So really grateful for the time that you've made today. Thank you to everybody that's joined us and for all the terrific questions. Now, I just wanted to finish that on Compass, if any of these conversations today have triggered anything for you, or you are experiencing or are aware of abuse in any form, then you can get in touch with the National Elder Abuse Helpline on 1800 353 374. Compass also has a service directory with over 500 organisations listed in different categories such as helplines, housing and accommodation, powers of attorney, legal matters, advocacy, and others. So that's also available to you free of charge. So thank you all very much. Have a lovely afternoon and enjoy the rest of your day.